Okay, we're doing very well. Next, Learning Unit 3, Closed Corporations. Remember, they could come in Closed Corporations Act 1983. They can no longer be registered, thanks to the Companies Act of 2008. Now, the idea behind ACC was that companies were very expensive to form. They were considered a privilege, not a right. It was a lot of litigation, a lot of paperwork. Ugh, no, we don't want it. So we start a CC instead. Now, CC, closed corporation. Now, why was it good? Now, when we talk about why was it a good idea, I mean, it was not perfect, but it was a relatively good idea. There are 9 things we got to talk about. Now, this is list. We don't like lists, but lists do seem to come up quite a bit. 9 things. So the first thing was that it was simple to form. All you need was your CK1 form. It's cheap to do. It was suitable for small businesses. You got that limited liability. You got that legal personality with fewer requirements. First thing, it's simple, cheap to form. Second thing, it is a juristic person. It's got its own legal personality. It's got perpetual succession. But members can still be held personally liable, which we will get to in a little bit. So simple to form, juristic person. Number 3, there are no shareholders. Remember, shareholders is only a company thing. However, we do have members who have members' interest. Number 4, only natural persons may be a member of a CC. What does a natural person mean? Natural person means they've got to be alive, like you or me. A CC itself is considered a natural person, which is a bit weird, but it is. But by and large, it's got to be a natural person. Number 5, there's 1 to 10 members, and there is usually, remember, this is the most common thing, no separation between ownership and control. In a company where there's a lot more turnover, it's a lot bigger, there's enough people for there to be separate directors and separate shareholders. In a closed corporation, it's like your mom and pop business. You don't have that luxury. So obviously the association agreement can change that, but there is usually no separation of ownership and control. There is the important thing, 1 to 10 members. Number 6, there is no restriction on the number of employees, the turnover you can make, or the value of your assets. So that's why it's like you've got as much freedom as you want in terms of doing business. You don't have to have like a maximum of 5 employees. You can have 1 million employees. You don't have to make within certain amounts of money. A CC could make 100 million rand a year. Many CCs do. You don't have to cap your assets at a certain amount. But you do have those restrictions, but it has to be 1 to 10 members. Number 7, the ultra vires doctrine does not apply to CCs. Now, if we remember, it used to apply to companies. We'll get into that later. So they're going to fund you. No ultra vires doctrine, they're going to fund you. So you're liable regardless of what happens. Companies nowadays, you are liable for what happens. You cannot say, I acted outside the powers that were given to me, therefore the contract is not applicable. Nowadays, regardless, you're getting funded. Number 8, your governing document. Remember, for a company, it's an MOI. For a CC, it is a CK or a CK1 form. They are interchangeable. Number 9, an association agreement is not required. However, it is the sensible thing to do, because the problem with there being such a low level of regulation is that people get batzach. People start to fight, and then the happy party stops very, very quickly. So all an association agreement says is, okay, we're all members. We run this particular business. We want the business to run in a certain way. This is how we are going to do it. So the characteristics are in order. Well, you don't have to put them in order, but just remember all 9. Number 1, simple to form, cheap to form. Number 2, regarded as a juristic person, has its own legal personality, has perpetual succession, but you can fund members. So simple to form, juristic personality. Members is number 3, not shareholders. Number 4, natural persons are members. Number 5, 1 to 10 members, and there is no separation of ownership and control unless the association agreement says so. Number 6, no restriction on the number of employees, turnover, or value of assets. Number 7, ultra vires doctrine is not applicable. There's no get out of jail free card there. That used to only apply to companies, doesn't anymore. Number 8, the governing document is a CK1 form or CK form. You can call it a CK form. Number 9, an association agreement is not required. There's no law saying you've got to have it, but it is sensible to have. Right, so those are the 9 characteristics that make up the legal nature of a CC. Now, if we talk about CCs, what did the Companies Act do to CCs? 2008 did a lot. Your CCs is finished. If they say describe, so you could get a nice 6 marker saying describe a CC in relation to the Companies Act. What do they want to know from you? They want to know, what did the Companies Act do to CCs? So the first thing and the most simple thing, no more CCs can be formed. No company, that's first thing. Second thing, you used to be able to convert a company to a CC. After 1st of May 2011, 1st of May 2011 is D-Day for everything in the Companies Act. You cannot convert a company to a CC. Side note, CCs, Companies Act came into being it was passed in 2008. It came into effect on the 1st of May 2011. So there was like a 3-year transition period. No more new CCs can't go from a company to a CC as of the 1st of May 2011. However, point number 3, CCs that existed before that point, before the 1st of May 2011, they can continue to exist. They are still legally a thing. They still legally have all the rights that they had before the 1st of May 2011. The structures are still the same. However, I'm saying that a lot. You can still convert a CC to a company. That's point number 4. Point number 5 is that if you do that, the solvency and liquidity test is applicable. And if the CC continues to exist, the solvency and liquidity test is also applicable. So you can't not convert to a company because you think that's going to get you out of your accounting obligations. It's not. Number 6, you need to have the consent of 75%, at least 75% of your members' interests. So if One Oak owns 75%, you're high and dry before you convert a CC into a company. So the 6 points are, no more, because of the Companies Act, no more CCs can be formed. No more companies can be converted to CCs after the 1st of May 2011. However, if your CC was existing before or on the 1st of May 2011. They can continue to exist like a sosa cracker. They don't have a problem. You can now convert your CC into a P2Y Ltd, or into a limited if you really want to. That's point number 4. Point number 5, your solvency and liquidity test is applicable if you are going from a CC into company. And if you are a CC and you still exist as a CC, it still applies to you. And a CC has to have 75% of the members' interest say yes in order to be converted into a company. Right. Next thing, folks, we are cooking with gas. How do we convert a CC to a company? We have to publish a notice of conversion. That's the first thing. We must issue that piece of paper, a notice of conversion. Then what we've got to do is, so in that notice of conversion must be a couple of things. First thing is the written statement of consent. So 75% of the members' interest needs to have signed that piece of paper. You must also have your MOI, your Memorandum of Incorporation, and you must have your filing fee, your brown envelope. Very important. So, notice of conversion, which must say, listen, world, we're doing this. In it must have your written consent of 75%, your MOI, and your brown envelope. Number 2, every person who is a member is entitled to become a shareholder. You cannot someone now say, hey, sorry, Johnny, you finished, you done. No. If he was a member, and unless he voluntarily leaves, you can't kick him out. So, notice of conversion, every member is entitled to become a shareholder. Number 3, and this is where the Mensa try to play games. The juristic personality of the CC continues, regardless of the fact that it is now a company. So if you owed 50 million rand as a CC, you can't now suddenly convert to a company and go, oh, sorry, clean slate. The company still owes the money. And by that same principle is point number 4. All assets, all liabilities, all rights, all obligations of the CC now belong to the company. Everything passes over. So we've got number 1, notice of conversion. Number 2, every member is entitled to become a shareholder. Number 3, the juristic personality continues from the CC to the company. Number 4, all assets, liabilities, duties, obligations, also you gooi them through. And number 5, any legal proceedings against the CC are now legal proceedings against the company. You can't just escape like that. Fantastic. Right. Now, let's talk about members' interest. Remember what we said in Learning Unit 1, that everybody must make a contribution. It must be service, it must be property, it must be money. Something like that. And all members have got to give some sort of members' interest. But the important thing to note is that the proportion of members' interest that you get does not have to be proportionate to your contribution. So just because you gave the most in contribution does not mean now automatically you get the most members' interest. I know that is not fair, but that's unfortunately the way it works. Your members' interest is expressed as a proportion out of 100. That's point number 3. You get a certificate of members' interest, which says, number 1, that you are a member, and number 2, what is your percentage of members' interest? And number 5, members' interest is incorporeal. Now that sounds a little complicated, but it's not. It is an asset, but it is not a tangible asset. You can't touch it like I can touch this cup. It is not fixed. Your members' interest could go down, it could go up. This cup is not going to change shape. And number 6, unless agreed otherwise, any duties, rights, responsibilities are proportionate to the member's interest. So if you have 25% of the member's interest, you are entitled to 25% of the profit. If you have 25% of the member's interest, then you are going to get funged for 25% of the liabilities if they start funging people for liabilities. So everybody must make a contribution. Members acquire members' interest. That's number 2, but it does not have to be proportionate to what they put in. Your members' interest is expressed as a percentage out of 100. Number 4, this is on the membership. This is on a certificate of members' interest, which says that you are a member and how much you've got. But this whole idea of membership interest is incorporeal. It's not tangible. It can go up and down. Number 6, although you might not necessarily get the most members' interest if you give the most in contribution, if you have the most members' interest, you are entitled to the most, unless that is changed by your incorporation agreement. No, not your incorporation agreement, excuse me, your association agreement. Okay, now, if they ask you to differentiate between acquisition and disposal of members' interest, this is what we're going to say. Acquisition is when you buy something or get given something. Disposal is when you're selling it or you're hoying it, regardless. So how do you get members' interest? You either have to buy from a member who has already got it, or you have to contribute money or assets or something like that to the company. So if, let's say, I want to buy Tabo's 10% members' interest, then I get Tabo's 10%. Everybody else's membership interest stays the same. However, if I now decide to go and contribute to Johnny's Plumbing CC, that's got 5 members, each owning 20%, and we come up with an agreement and blah, 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 now we're going to have 6 members, then everybody's membership interest decreases proportionately so that I can get membership interest. So if you bring in a new oak that somebody hasn't sold to, then everybody goes down. Of course, if somebody has sold to him, then nobody changes. But if you have, for example, 4 members and who each own 25%, and you bring in a 5th member, now each of your members has 20% and not 25%. So either buy from a member or you contribute, and then everybody decreases proportionately. Those are your 2 ways to acquire membership interest. Disposal of membership interest either happens in 3 ways. It happens in one of 3 ways. If the guy dies or becomes insolvent, if he sells, or if a court stops him from being a member. He gets terminated by court order. Now, if you dispose of your membership interest, the other members have what's called the right of preemption, meaning you must offer your membership interest to them first before you have the right to sell it to anybody else. And if you die, they can transfer your membership interest to your kids, really only with the consent of the other members. If there is an issue where they say no, then you sell. Then you can sell to anybody. And of course, all of this is subject to the association agreement. So acquisition, when you're getting it in, you get it by buying from a specific member or contributing to the partnership, up to the CC as a whole. And if you contribute to the CC as a whole, then everybody goes down proportionately to make space for you. Disposal, if you're dead or bankrupt, it goes. If you sell, it goes. If you sell, you have to offer the other members first. If you are dead and it goes to your kids, the or to somebody else that you've left it to, the other members must say yes. If they say no, you gooi it to anybody. Right. Let's talk about the duties of a member to the CC. Number one, they have a fiduciary duty, which is act in good faith. Don't be a dishonest oak, unless that's the nature of your business. Don't be dishonest. Act in good faith, act honestly, act in accordance with the law. Don't be a doers. The second thing is that you have to act with a duty of care and skill. So don't go blow the membership in, don't go blow the profits at Grand West on one day. Don't go to Pep stores and buy a whole new wardrobe. Don't do stupid things that are going to put the business into trouble. So the first thing is act in good faith. Be an honest oak. The second thing is duty of care and skill. Do what a normal person would do if they're running a business with the idea that they're going to make a profit. Don't do stupid things. Don't be a stupid oak. So be an honest oak. Don't be a stupid oak. However, if there is such a case where a member is compelled not to follow those two, the other members have to say, okay, we are letting you do this, that, and the other thing. We are giving written consent to you doing this, that, and the other thing. That would otherwise mean that you were violating your fiduciary duty or duty of care and skill. However, if in any other circumstance they don't follow their fiduciary duty and their duty of care and skill, they're now personally liable for their breach of duty. If they lose the company R1 million, the CC R1 million because they acted without care and skill, then they're going to get fined for R1 million. Personally. Right. Now, how do we gooi them out in court? Cessation, CESSATION. That is a very important word to know. So what we're going to talk about now is your cessation and your two main remedies. How do we gooi them? So cessation refers to when you are gooiing the people out of the CC. You go to court, you say, get rid of them. How does that happen? Why does it happen? You gooi them out because the CC is in serious financial difficulty. The oak is just a bloody liability and you've got to get him out. Or there is a deadlock and one or more oaks is making the CC not be able to carry out their business. So then you gooi them. So there's two ways that you can gooi them. Number one is Section 36. That is when you throw him straight away. You terminate his member's interest by court order immediately. Section 36, thanks for coming, you're gone. Section 49 is when the court gives assistance to the other members where one or more members has been found guilty of unfair conduct. Basically, it's the court saying it's not chucking the guy out, but it's forcing the guy to act in a proper manner, or saying behave. So cessation is when you are you're ending the membership interest by court order. It happens in cases of financial difficulty or if there's a deadlock. Section 36 of you chucking them out completely. Section 49, you're getting some sort of assistance from the court and you are asking for that because the guy has been found guilty of unfair conduct. So they say, okay, now he's been found guilty of unfair conduct. We as the other members need the court to say that the oak has got to do this and this and this. Okay, now let's talk about loans. You cannot give a loan without the written consent of all the CC members to any other closed corporation where one or more of the members together hold 50% of the membership interest of that closed corporation. So if Johnny's Plumbing CC wants to give a loan to Jane's Gardens CC, but Johnny's friend Bill, who is one of the shareholders, one of the members of Johnny's Plumbing CC, owns 50% of Jane's Gardens, then you can't do it. So if one of the members of the first CC owns more than 50% of the second CC, can't give it a loan without written consent of all of the members. You cannot give a loan to a company that is controlled by one or more of the CC members. So 50% for another CC, anything more than 50% for a company, because that is to prevent an abuse of funds. Remember that there's no alter virus. All CC members are both principals and agents to contract on behalf of the CC. Even if what they are the CC could be selling garden furniture, but they could be contracting to buy jumbo party balloons. The oak that is contracting, unless he has specifically not got that power, unless it is in writing that he does not have that power, can be assumed by the third parties to have had that power. Remember, we discussed that that's ostensible authority. So, fang him. Simple. Now, the last thing we're going to do is talk about the personal liability of members. There are 4 ways we can get them. Number 1 is under Section 65, where there has been a gross abuse of the CC. That's basically corporate veil, pretty much. If the oak has used it to commit fraud and malfeasance and everything, fang him personally. Number 1, Section 65. Number 2 is Section 23. You've got to have the CC's name and the name of the members on all documents, checks, orders. If it's not there and he's being sketchy, fang him. So Section 65, where there's gross abuse. Section 23, where the name must be on everything. Number 3 is Section 52, which prohibits loans. If the oak is making loans when he shouldn't, personally liable. And number 4 is Section 64. If he has acted recklessly or fraudulently, not necessarily gross abuse, they are mutually interchangeable, but if he's acted recklessly or fraudulently, then fang him. So, Section 65, where there's gross abuse. Section 23, where the names are not where they should be. Section 52, which prohibits loans. And Section 64, where members have acted recklessly or fraudulently. And that's Learning Unit 3.